must be our goal and our guide. And all that we strive for as a human family, dignity and hope, progress and prosperity, depends on peace. But peace depends on us.
Morning, viewers, thank you very much. We have been listening to the Supreme Court of Kenya in the Republic of Kenya this morning. They were making decisions and they will be making a ruling about the building of bridges initiative. We across the continent of Africa always find solutions for our problems, Captain. Yes. We seek to find solutions.
Yeah,
Thank you very much. Hold on. Just mute a bit, then I finish the introduction. Thank you very much, viewers across the continent of Africa and the globe. This is Punchline Africa Television. We are bringing you live diaspora dispatches across from Nigeria in Abuja, where at the trial of Nnamdi Kanu on charges of treason and others, who was actually taken into custody by Buhari government. It has brought international aspect, and that is why, as a Pan-African station, we're equally interested to bring out to our viewers on this our show called Diaspora Dispatches. With me to carry out this noble duty, we have live our correspondent in Abuja, Captain Chikwas Onu Ikipe, who is on the ground in Abuja, who is going to be our regular in Nigeria to bring us news across that continent, as part of the continent in West Africa. As you know very well, we have to network with other agencies to get news from across all parts of Africa. And then we have been, for example, to exchange our notes with other parts of Africa. From East Africa, we have been in the Supreme Court in Kenya, working out modalities of uniting Kenya. While in Nigeria, they are struggling to see that Nigeria doesn't disintegrate. And other people say they need a referendum to go away. So these are two positions that I would like us to discuss and look at this morning. With me to go through all this is none other than our senior anchor and a senior editor, Miriam Ogutu. Good morning, Miriam.
Doc, a very good morning to you and good morning to our viewers. Good afternoon, good evening, depending on where you're tuned to us from.
Yes, and also on the panel is our investigative journalist, none other than Sean Wesonga. Daniel. Sean, good morning.
Yes, a very good morning to you, Dr. Masanga David. I'm joining the conversation from Nairobi, Kenya. Good morning to our viewers here in Kenya. Good afternoon, good evening, depending from where they are watching us from. And of course, it is my pleasure to be on this panel this morning.
Thank you very much. And also across in Abuja, in Nigeria, the capital city of Nigeria is Abuja, the commercial city is Lagos. Good morning, Captain Chikwasa Onu Ikipe. Good morning.
Good morning to you, Dr. David Matsanga. It is good morning from here. Thank you very much.
Take us through the events of the day today. What is going on there? Are journalists allowed now to go inside? What is the situation? Has the case started? What time did it start? What are they going to do this afternoon or this morning? What is new from yesterday?
Okay, Doctor, as we all know yesterday, from yesterday's updates and proceedings, yesterday there was a stumbling block to the procession of the trial in the face of the fresh charges that was trumped up or profiled against the leader of IPOB. To that effect, the defense team had to object that very charges and asking the court, the presiding judge, to give time for them to interact with the client and also to study those charges. And today is the second day of the trial. Today, the defendant is expected to take a plea of guilty or not guilty. And on this very day, as usual, traditionally, you could see security operatives. You can see the DSS, as the Department of Security Services. And you can also see vehicles of the police, vehicles of the army. Some of them are still coming on their way. I cannot tell you that. They are still coming. You could see even customs. You could see even Federal Road Safety Commission, which should be somewhere controlling the vehicular movement somewhere in the town. But they are all here in order to restrict freedom of movement, in order to restrict freedom of citizens, the fundamental human right of citizens, which they have to, attend court proceedings, to attend the court matters in the country. Now you could see the blazing sounds of the siren protruding from these trucks. They are coming on their way as if we are in a battlefield. The police, RRS, FCT, Abuja, the civil defense, mention them. You can see them. The National Army that should be somewhere protecting the external, or should I say the integrity. You can see Army War College. You can see that. Are we in a war? That is the question we should ask. Are we in a warfare? Africa, Africa, Africa. That is very sad indeed. So they are still coming on their way. And from all indication, it appears that the leader of IPOB is on his way coming, because from what we are seeing, it appears they are gonna bring him in the courtroom in no distant time. So that is the situation report now. And as usual, the front yard of the court premises is tense. You could see other journalists here gathered around the corners, all of whom we are not allowed to access the courtroom as well. So that is it, Doctor, for now. I shall stand by as usual. Thank you very much.
Before you go, I think I needed to ask you a few questions, because we want our listeners and the viewers across the world to know, understand what exactly, where did Nigeria go? Where did Nigeria begin to go to this level? A situation of a political nature. And I've insisted, and I still insist, that the situation in Nigeria can only be resolved through a political solution, judicial, military, or any other means cannot solve the situation of Nigeria. The people of Biafra asked for a referendum. They wanted to vote whether they remain in Nigeria or they go away and form the state of Biafra. The government knows the cause. After all, a referendum is enshrined in the United Nations Charter that the people can decide to leave when they live with the consent of the majority. It is normal on international norms and obligations. Where did we start going wrong? Take us through that history as we wait the arrival of the leader of IPOB, Captain Miriam. I think we got the captain is still arranging his equipment. let's go back and see where Nigeria went wrong. It sank into a level where we now have people fighting instead of discussing, where we have police state instead of normal state, where we have a country divided by rebels, bandits, terrorists, name them. Where did we go wrong from here? Miriam.
All right, maybe I just give a little bit of a background information, which Doc you've done, and our correspondent. Captain, could you mute your device for just a few minutes? We'll get back to you. Thank you. So perhaps for the viewers who are joining us right now and you don't understand what is happening, let us just bring you up to date, because the trial of Nnamdi Kanu, the leader of indigenous people of Biafra, was adjourned until today. It was curtailed on Tuesday due to the late service of the amendment charges on the secessionist legal team. Binta Nyoko, the trial judge, after rejecting the prosecution's excuse for the late service of the newly amended charges on the defense, expressed displeasure over how the attitude truncated the day's proceedings, forcing her to adjourn the case until today. The Nigerian government had on Monday served an amended 15-count charge on Mr. Kanu's legal team. Mr. Kanu, who is being tried on a 7-count charge bordering on treasonable felony, was expected to take a fresh plea to 15-count amended charge dated January 17, 2022. At Tuesday's sitting, Mr. Kanu, who had engaged the services of a prominent lawyer, Mike Zehome, to strengthen his defense team, told Ms. Nyako, the trial judge, that he was only served with fresh amendment charge on Monday, which is morning, and the business of today is to deal with 3 subsisting applications: application for transfer, motion for bail of the defendant, and preliminary objection raised in respect to the earlier charges in October last year. And of course, the defense lawyer with the amendment charge only served on him Monday morning. He had yet to discuss the contents of the fresh charge with Mr. Kanu, but the judge disagreed with the lawyer, insisting that the matter was for trial. And the additional charges, the fresh amended to the case by the prosecution, so addition of 8 charges to make a total count of 15 counts in the court document signed by the Director of Public Prosecution of the Federal, Mohammed Abubakar, which was filed barely 24 hours before the commencement of Tuesday's proceedings. The IPOB leader was accused of making a broadcast received and heard in Nigeria and in furtherance of an act of terrorism against the Federal Republic of Nigeria and the people of Nigeria. The said broadcast, according to the charge, was intended to destabilize the fundamental political and economic structures there in Nigeria. And in count 10, the charge said between 2018 and 2021 that Mr. Nnamdi Kanu of Afara Oku Ibeku Umahia North Local Government Area of Abia State on diverse dates made a broadcast received and heard in Nigeria within the jurisdiction of this court in furtherance of an act of terrorism against the federal. And we know the Radio Biafra that we've had several times. So the government is saying this platform is being used to further some things that goes against the Constitution of Nigeria. And so that is just in a nutshell what the latest is there from Nigeria, and we shall continue, with bringing out more details of this case as we continue with this conversation.
Thank you very much, Miriam. It is actually, most people are saying it's not a trial, it is just a detention without a trial. Because I don't think the Sharia courts of Nigeria will give Nnamdi Kanu a fair trial. Where you have, Miriam, we have a judge, a Chief Justice of Nigeria, who says his papers were eaten by termites. So he was appointed as a Chief Justice without papers. So, Miriam, in a sense, and a few words, I don't think there is a trial here. Since you have a judge whose papers were eaten by termites, and then you have, the mice, rats came to eat a president's office. You remember Buhari's first term, rats came and ate the entire office. These are 2 bad omens. You know, two bad things that have happened to Nigeria. If a rat eats your feet, then you have a problem. You must cleanse yourself very fast in African culture. And then termites look for your papers, then you have nothing to tell people. So how do you expect a court with a chief justice who has no papers to sentence a person on which law? This is exactly what I want to put to my listeners. Captain Chikwasi Onu Ikipe, are you back now?
Very well, we are here. Thank you very much.
I am asking the Chief Justice of Nigeria told us that his papers were eaten by termites. Did he get his papers back or copies?
It is laughable indeed, and it is ridiculous and also ludicrous at the same time, because what is happening, I cannot stop laughing. What is happening in Nigeria, in Africa in general, it's nothing to write home about. The same thing applies to the president of Nigeria. Up until today, as we are talking, cannot lay hands to the or his class 6 certificate, that is the first school living certificate, or the WAEC, I should say, the West African school certificate examination, a proof that he passed through class 6. Up until now, they cannot lay hands to that. And may I also remind you that it is one of the prerequisites, you know, for being a president or for contesting a president in Nigeria. But all of those we are jumped through, all of those we are, you know, are not applied. The same thing applies to the CJ and the Chief Justice of Nigeria. A lot of anomalies was, you know, put into place to ensure he ascended, or he went through to the office of the CJN by all means, because what we have here is more of ethnic politics. When we have a Fulani man as a president, when we have a Fulani man as the CJN, when we have the Fulani man as, you know, heading the various executive councils, various executive offices, even judicial offices, you know, so it is not surprising at all. That is what we have here. And regarding the court session, as one of my colleagues there with you said, today we are expecting the defendant, the IPOB leader, to take a plea regarding the fresh charges. And of course, we shall see how it goes to that effect.
All right.
Yes, Miriam, you had.
I have a question to our guest before we allow Daniel to come in. Captain Chikwas, if you can hear me, there is an interview that former President Olusegun Obasanjo did some times back, and he was asked about what is happening there in regards to the detention of IPOB leader Nnamdi Kanu, and he was asked if at all it was a good thing for the President Muhammadu Buhari and Kanu to have a conversation over what the problem would be. And I'll just read out his response. This is what former President Obasanjo said. I don't see anything wrong in that Buhari meeting with Kanu. I would not object to that. If anything, I would encourage it. I would want to meet Kanu myself and talk to people like him, people of his age, and ask them, what are your worries, not only from the Southeast, but also from all Nigerians. And he also said that the heavy boot response to Biafran sentiment is not the solution. So that is what the former president said. I don't know, what is your response to that?
What is happening in Nigeria, I don't know. It is something that is, if you are not careful, it might consume you as the president. In the case of Obasanjo, during the administration of Olusegun Obasanjo, being the first president in the democratic settings of Nigeria, he applied what I would call a human tactics, you know, during his own administration. When something like this happened, one Sarido Kubo emerged as an activist who, to all intents and purposes, was fighting for the rights of his people of the coastal region and Biafra as well. To an extent, he was treated the same way the leader of IPOB was treated, but at that time, a political solution was employed. In the case of Sarido Kubo during Obasanjo's regime. Now, fast forward to what we have here in the regime. I keep saying regime in the case of Buhari, because this is a regime. He is still in the settings of the military rule, where he has also been advised if he would insist on the legal perspective or the trial of Nnamdi Kanu, he should do that without any further ado. But they wouldn't want to do that. Let it be put on record that Nnamdi Kanu was arrested in the first time on the 14th of October 2015. He was arrested somewhere in Lagos. He was held incommunicado for a number of days. After he was brought to court, I wouldn't say arraigned, he was brought to court and imposed, or should I say, there were trumped up charges against him, which they did not allow him to even speak up and defend himself. Those charges lingered, 11 count charges then, lingered until the time they could not provide what we call prima facie evidence. Those 11 count charges, about 6 of them were struck, remaining 5. They could not provide evidence or shreds of evidence from 5 to 3 until Nnamdi Kanu's home was raided. He has to take a flee, He has to seek asylum somewhere in Israel. Now let's fast forward to the second time Nnamdi Kanu was arrested, this time illegally, somewhere in Kenya. It was extraordinarily renditioned to Nigeria. And that was on the 27th or 29th of June. I cannot remember the exact day, sometime in June 2021. He was that moment abducted back to Nigeria. They brought him to court again with 7 count charges, frivolous and trivial charges. From the 7 count charges, they also increased those charges to 15. That is where we are now. And the question one would ask is, are they serious in pursuing this matter? Are they really in the procession to ensuring they convict, in quote, this very criminal, if we should put it that way, this very prisoner? Are they ready to convict them? If they are ready, they should process with the legal matters. That is to tell you they are not. They just want to mark time. They just want to, keep him incommunicado. They just want to torture him mentally and psychologically in order for him to be down, to be dead, in spirit. So that is what we have here. That is what we have here, Miriam.
I thank you very much on that one. In addition to that, before Daniel comes in, Miriam, the situation in Nigeria is there is no government. There is only government by paper, but there is no government in Nigeria. I think let's begin to admit that. A government that allows its people to be eaten. The ISIS are eating people. Let's call it literally eating. They are cutting people's limbs in the north, in the Maiduguri area. Each state in Nigeria is bleeding. The bandits are kidnapping people. Nigeria has become a state of kidnappers, where younger girls are being kidnapped, killed, maimed, raped, defiled. We shall have no girls in Nigeria very soon. Nigeria has become a true country of a state without a government. Nigeria qualifies to be a pariah state. The only thing we are left is a flag and the president tall, 6.4 feet, walking around conferences. but Nigeria is dead. People are dying of poverty. There is no electricity. Hospitals are not functioning. Roads have become craters. Craters are on the road. Corruption is on the high rise. Rampant discrimination, abductions and killings, destruction of property. Tell me if that is a state, if it's not equivalent to Somalia. Kidnap, shootings, killings. That is the state of Nigeria today. It's unfortunate that African Union is not seeing this. It is unfortunate that African Union cannot come out viciously, stand up and talk. Otherwise, Miriam, there would be a lot of consequences. If we had been united in Africa, if we had a better African Union, a country like Nigeria would be expelled from the African Union. It will not be anywhere near the African Union because it doesn't pay us at all. It destroys us, the image of Africa. 220 million people who would be consuming our goods from Kenya are busy killing each other. You can imagine. They are busy killing each other. And Buhari is busy amassing wealth and even thinking of marrying another wife at the age of 86. 86 or 88. He wants to marry. You know, this is the tragedy of Africa. The president is thinking of marrying another wife. Well, his religion allows him to marry another wife. The other one whom he has, they are not in agreement. You see, Nigeria is the only country in Africa that has touched a lot of money outside Africa. Even the elite in Nigeria, look at Dangote. He does not even bank his money in Nigeria. He banks his money outside in Europe and America. It's a shame, it's a big tragedy for Nigeria. So if you come to the Sharia law, the Chief Justice does not have papers. How will the Chief Justice direct the court? When he was asked whether he has papers, he said the papers were eaten by termite. So here we are. This is where we are. This is how we are. That is the state of Nigeria today.
All right, Doc. And I see that
yes.
I see that our guest from Nigeria is positioned in a different place. But before we go to him and get the latest, perhaps to give Daniel a chance to just make his submission shortly, and then we will get to Captain Chiko is there and tell us what is the latest. I've seen, I don't know if that is the media somewhere there postured, but he will let us know what is really happening there. Daniel Masonga, your thoughts in what is happening, and perhaps those sentiments by former President Olusegun Obasanjo, who is saying this military approach towards the IPOB is not working. Could we perhaps embrace talks?
Thank you, Miriam. And of course, Nigeria is in a state of despondency, just like Dr. Masanga David, yourself, and my brother Chiko Asonukipe is saying. This country has been captured by the Fulani tribesmen who are cronies of President Muhammadu Buhari, and they're inflicting every kind of brutality and violence on the people of the Igbo nation. And just whatever is happening today is just a tip of the iceberg of whatever has been ongoing throughout the years. In his preamble, Dr. Masanga David said that the people of the Igbo people of Biafra actually are entitled to this right to chart their own destiny, and that is actually captured in the UN Charter. and therefore there should be no any particular instance where they should be denied maybe to hold a referendum to determine their own destiny. This actually reminds me of the people of West Timor, where Indonesia had refused to give them a referendum, and when they finally held a referendum, the government of Indonesia actually funded militia who butchered a lot of people in East Timor, and those are wounds that do not just heal over time. But in Nigeria, you realize that already we are having, over the years, people have been butchered on the streets. Today we are having Nnamdi Kanu being held in a court where the judge who is presiding over the case is not someone who do not have credentials other than being a Fulani and a crony, a close ally of President Muhammadu Buhari. So I believe Nigeria is in a state of lawlessness, and this is because a few individuals, few selfish Fulani individuals, have taken the state under its throat, and they're actually in a state of strangulating the entire nation into submission and to actually subdue them to the will of President Muhammadu Buhari and his few Fulani generals who are actually meting violence on the people of Biafra and the rest of Nigeria. So to me, just like Dr. Masanga David, I believe this is not a trial, but this is being detained without trial. Because at the end of the day, I believe this is just a circus. Nnamdi Kanu is not going to be released. He might as well be taken back to detention, and the longer he stays into those detention cells, the more the people of Biafra suffer anguish, and actually the state of discrimination and despondency sinks into the masses. They say that justice delayed is justice denied. And that is why I agree with Olusegun Obasanjo that the military strategy should be done away with. Let the government of Nigeria engage the people of Biafra, let them talk and make preconditions on how they can be able to hold a referendum and allow these people to decide their own destiny. But anything short of a referendum and peaceful talks, Miriam, I believe that is an injustice and it's a criminality against humanity. And the ICC should be looking at what President Muhammadu Buhari is doing to the people of Biafra, and also the AU and the ECOWAS. I don't know what they are doing at this particular moment when a lot of people have lost their lives. We still have insecurity in most parts of Nigeria, including the northern part of Nigeria where the president comes from. And also now the issue of Nnamdi Kanu. I believe it is a time where African leaders, especially those in ECOWAS and AU, should come on board and be able to reinforce dialogue and the referendum to happen in Nigeria, so that the people of Biafra can have a closure on this matter and Nigeria can be able to move forward. I submit. Okay.
Thank you so much. And as I see the army tracks around the streets, as we've seen our correspondent from there, Captain Chikwas, because I'm coming to you, I'm just thinking if we could have this kind of reinforcement in places where Nigeria has been experiencing insecurity, perhaps the issue of insecurity could halfway been addressed there, but that is a conversation for another time. Captain Chikwas, I don't know what is the latest there, and has Nnamdi Kanu arrived in the court yet? Captain Chikwas.
At this moment, we are still not in the know to that effect, but we are suspecting everywhere is tensed. The degree of tension has risen to a huge crescendo. So we await further information to the aspect of the arrival of the defendant, that is the IPOB leader, Nnamdi Kanu. But before then, we have a team supporters of the Biafra struggles. That is family members of the IPOB movement gathered here in solidarity with Nnamdi Kanu. So we shall speak with one of them in an interview section to knowing their name and also why they are here, to what they are here to do and why they are here as well. So I am going to be joined by one of them at this moment.
Yes, are you able to put one through to us, just one of them shortly?
Okay.
Yeah, where is the brother? The brother is my friend.
No, not the brother, just one of the supporters there. Perhaps he tells us why he feels it's important for him to be where he is today.
Okay, yeah, go ahead.
Okay, thank you very much. Thank you very much, Mister. We want to know your name.
My name is Nnamdi.
Okay. Why are we here, please?
I'm here in response of my case today, which is Biafra versus Nigeria.
Okay.
Which they adopted our leader, Nnamdi Kanu. That's the reason we are here.
Okay, you are here in essence to support the leader of IPOB, Nnamdi Kanu.
I'm not supporting the leader of IPOB because he is there for my sake.
Okay.
He commits no crime. He is there for us to be free. So I'm here for my own case.
Okay, could you tell us more about the case, please? Because the whole world is listening and watching at the same time, Africa in general.
From what I'm saying here, since yesterday I've been here, the DSS, Army, police, mobile police, and rest of them, those civil defense, all of them are here. Restrict the whole people not to go inside the court. Even if our lawyers, they deny them the access to go inside the court. So whatever we have done to these people, we are in the court. Let the judgment be here and let us know what is happening between Nigeria and Biafra. They don't want to say anything and they don't want to make justice prevail. So they are just humiliating us one way or the other. We don't know. They are using the oil in Biafra land. They are using everything in Biafra land. But there's no infrastructure in Biafra land. There's no education. Even if you after you graduate, there's no work for you. That is what you have been suffering in the hands of Nigeria. Now, we say no, enough is enough. We cannot continue to suffer, to die in our own land. We decide to be on our own and then disagree. You don't want us to be on our own, and you don't want us to come closer to the government of Nigeria. Allow us to be. That is the only crime we committed.
Okay, thank you. As you put forward that you are here for the case of Nnamdi Kanu and by extension your own case, do you believe in the judicial system of Nigeria? Do you believe that you and the entire Biafrans will get justice in this very court?
I wonder, I doubt, because since 2014 to 15, if I'm not mistaken, or 16, this matter has been here. There is no fair trial. There is no justice. Many judges have tried this matter. None of them can come up with the truth of the matter. They know the truth. But for them to say the truth, they will not say it because all of them have been paid by the government of Nigeria, by Muhammadu Buhari. Now, in this cause, I wonder, I'm not seeing any justice in this cause. Because each day we come to court, then we'll come with fresh charges that mix nothing. Each charge, then we double it times 10. Yesterday, they just brought another 15 charges. So all these things they are just doing the wrong thing at the right time. The good thing they are supposed to do, either release our leader, we will go. But if they insist holding our leader, Nigeria will know no peace. They will never see peace.
Okay.
All right, Captain Chikwa, I would like you to ask one more question. Perhaps you could put it through the person you're speaking to there, because we know that the government of Nigeria has been going after anybody who's perceived to be supporting or being a member of IPOB, and now he's speaking to us. So there are very high chances that officials from Nigeria could see him speaking to us. Is he worried about his safety as an IPOB supporter and member?
Of course, I would ask him that. So please, Mister, I hope you are comfortable with this interview and not releasing your name afterwards.
No problem.
Okay, before I let you go, I want to ask you, and in simplicity, what do you want? What do you want? The release of Nnamdi Kanu, the IPOB leader, or do you want an oust from Nigeria? Tell us in simple terms, please.
Number one is this. Let them release our leader, Nnamdi Kanu. We'll start from there and let them allow Biafra to be. Look at Abuja. Just look at the entire environment. It's good, but come to the east, you will never see anything good. While everything that I've been using to build up this Abuja of a thing come from the east. So why? What are they holding us for? We need total freedom.
All right.
We need total freedom.
All right. Thank you very much. Your first name, please. Your first name.
I believe I pick it from here that what the gentleman there is speaking is they don't have anything to hang on. The whole of southeastern Nigeria is in chaos. Yes, they don't have anything to hang on. And he's right. He's right as a citizen of the country called Nigeria to fight for the rights. Sure, Miriam. Look, Abuja is very smart, but there are people in southeast Nigeria who are sleeping on water. On water. Their houses are built on water in the Delta region. You see these pictures on BBC. It is very embarrassing for a country that has all the resources, the money, the will. Sad, very sad. So thank you very much.
Okay, send it to me. Send the number.
All right, Captain, thank you so much for muting that. I don't know, Daniel, some issues that, the IPOB supporters there have brought up, and I think this is something that we've been talking about now, the discrimination. And he said, look at Abuja, where he is right now. Everything seems to be working. It's lovely, but that is the opposite of where he comes from. So systematic marginalization of a community and the people is asking now, if you don't want us to benefit from this government, but you're still insisting for us to continue staying with this government and country. I mean, it's not working. Things have fell apart.
Yes, thank you, Miriam. And I use the example of East Timor in that particular matter. That was what was happening during that time. One side of the nation felt like the other side was developing, and their side was being neglected and abandoned. And that is what is happening in Nigeria. These are systematic marginalization of the people of Biafra, just to ensure that they disfranchise them and make sure that they do not prosper and benefit from the government of the day. Yesterday, I remember in our discussion, I said, you will find so many Biafran in abroad who are very great in their field of studies, some who are medical doctors, some who are engineers, some who are even business people. And this is an acumen and maybe the brilliance that is inborn, and there's no one who can take away from it from them, because even the colonialists, when they are leaving Nigeria, they understood that the country will only be safe and achieve progress if the people of Biafra were in leadership. So to me, I believe perhaps that could be the reason why President Muhammadu Buhari is trying to maybe persecute these people and be able to marginalize them. It is the same thing that happened to the Jewish race in Germany, where Adolf Hitler put all of them in a concentration camp and in the Jewish ghetto that they are famously known. So to me, I believe these are crimes against humanity. This is a crime against Nigeria itself, in that a certain portion of the population is being subjected into undue torture, discrimination, and also brutality by the state itself. So to me, I believe this is the solidarity that the people of Biafra should be showing to their leader, Nnamdi Kanu. And I really don't understand why we do not have so many people coming to the streets and demanding that their leader be released unconditionally, and also the talks for the referendum be set so that Nigerians can be able to determine what they want with their future. Because, Miriam, I believe where I sit right now, that it is not only the people of Biafra who are feeling the heat of the bad leadership which is happening in Nigeria today. It is the entire nation, because Lagos, you go to cities like Lagos, you realize that there is no electricity. We still have shanties inside the city. We still have people who cannot afford a meal of $1 a day. So that begs the question, is this the right leadership that the people of Nigeria should be having in place? The answer is no, because President Muhammadu Buhari has turned the government into a Fulani affair, and therefore, even in this particular government, there's no regard for brilliance, or there's no regard for people who excel in their careers, who can be taken into government and be able to reform and turn around the country's economy. So it is a time for the liberation of the people of Nigeria. Let the people of Biafra come out in large numbers. Let the Nigerians of goodwill, who mean well to the nation, also come out in large number and be able to support this particular cause. We have to liberate Nigeria, and therefore also we have to call on the African people, wherever they are, to come out and support and end this impunity that is happening in Nigeria. I submit, Miriam.
Okay, thank you so much. And on the issue of electricity or lack thereof, I think I was reading another article in one of our papers here, and the reason the government of Nigeria has given for the problem with electricity in the country is because they have obsolete equipment. A whole country, the most populous country in Africa, has obsolete equipment when it comes to its power transmission. So that has been affecting the power transmission in the country. What a joke that is. Okay, and Doc? Yes, we're back to you. You're muted.
Yeah.
Yes.
It's a tragedy.
It is a joke.
Then this one who has been here saying every perspective is wrong, take him off. This one here, the one in yellow. These are the Nigerian spies who come on they tell us the perspective. Open up and tell us the new perspective. Why are you writing on the chat? Open us and tell us, or else you get out of our platform. You can't be there listening to us without telling us. Then he is writing, criticizing us. Unaona Medium is criticizing us, that all of us. These are the Nigerian embassy. See, open up and talk. Don't talk in darkness. We want to see your face.
Yeah, we would like to hear your perspective or deny.
We are democratic people, and we don't want, maybe we are wrong. Tell us what is right in Nigeria. Yes, we hear you, but we can't hear somebody whom we don't see.
Can't you see me? Don't you see
no.
me?
Your volume is so low. Could you,
boss,
yeah.
You are upside down. Your picture is upside down.
And your volume, I don't know if you can do anything about it. I really can't hear you literally. So, but we would really love to hear your perspective.
We want to hear your views.
Now, if I can rotate the picture, as you said, I'm standing. You can see, I'm using laptop. I'm not using phone.
You cannot be heard. So once you're able to fix that, maybe you can rejoin us back. But
don't let people say, Miriam, we can hear. Let's hear. Let's hear what he's saying. You say we are wrong, sir. Yes. Let's hear what you are saying.
I was listening to Daniel.
Yes.
Listening to Daniel's perspective. Number one, Igbos are not Biafrans. Biafrans are not Igbos. Igbos are different from Biafrans. And if you don't know, you have to go and study about the Dojuku civil war. And you have to study about the structure of Nigeria before Biafra. Dojuku did the same thing Nnamdi Kanu did by feeding our people wrongly based on own perspective. When they went to Aburi Accord, have you studied the Aburi Accord?
Doc, even the viewers are saying they can't hear him. Okay. I cannot hear him myself.
Okay, boss. I think when you put up your equipment, you are bringing in history. Amongst all the people on this platform, I am like you. I'm 67. So I understand the Nigerian Biafran war. 2, I'm also a soldier. 3, Uganda was one of the countries that recognized Ojukwu and the rest. So clean your equipment. This is the embassy staff here. He's gone. Miriam, let's continue with our work. He's just hidden in darkness. A good guy cannot speak in darkness. This is an evil who has been sent here. Perhaps these are the people who even kidnapped people from Kenya here. So he's looking for whom to kidnap. You see? So let's go. Miriam, we had our points very clear until we are disrupted wrongly by this gentleman, and we wanted to hear his views. He was saying Daniel was wrong on the question of Biafra, that Biafra is not Igbo. I don't know what he means. So in any organization like Amazonians, they are also divided. They are Amazonians A, B, you see why they are Akaranga and the rest are fighting in Amazonia and Cameroon. My West African friends always amuse me with that type of divisions. They multiply each and every day. So we are not going to listen to.
All right. And one of our viewers here is saying the reason why you hardly see people in a larger number coming out in protest in the streets of Abuja is because the Nigerian army and police will kill the people. I am explaining this because Daniel is calling for that protest, and the only means we can register our protest is to sit at home in our region. And so there were claims that IPOB had issued some sit at home order, and then I think I read somewhere which was a bit contradicting. So I don't know what is the position here, Captain Achikwas. Has IPOB issued a sit-at-home order as the trial of Nnamdi Kanu continues?
Well, in response to that very complexity of orders, it is worthy to note that a couple of days ago, the IPOB Administrative Office issued, that is the Directorate of States of Indigenous People of Biafra. They issued a press statement that the only moment that is meant for a sitting exercise or sitting protest is the only day or days slated for the appearance of court cases of Nnamdi Kanu. So it was only the 18th of January that was officially announced a sit-at-home day, you know. Then it was unbeknown to the body that the court would adjourn that very proceeding or trial to this day. So whatever sitting exercise that is being observed, allow me to say, is a voluntary one from the people in solidarity with the leader of the indigenous people of Biafra. Allow me to also connect these dots, ranging from the question you asked some time ago, or Daniel asked, I'm sure Daniel asked that question, why people are not, or why he isn't seeing people on the streets protesting or chanting songs, you know, in the release, towards the release of Nnamdi Kanu. The reason is very simple. You know, when in the quest for self-determination, in the quest for freedom, there are so many adoption a freedom fighter should adopt to make sure everything works and freedom is achieved. Before now, there are marches in Nigeria. I mean, in this very case, there used to be marches in Nigeria, you know, protests and rallies. But did you know something? The Nigerian military, as you see here, a replica of what you are seeing here, would trump up from, you know, from only God knows, shooting live bullets and tear gas canisters, shooting tear gas canisters to unarmed people, which is everywhere online. Since 2015, they have been doing that, killing people, and nobody's talking about it. Amnesty is not talking about it. Of course, they did release a report in that regard. But what happened? You know, the world is not talking about it. The Human Rights Watch is not talking about it. So it was overthought that the only procedure that would work is to, you know, stage a sitting protest. That is a sit-at-home exercise. The Biafran people had to sit in on the court date of its leader, Nnamdi Kanu. And in that case, the people of Nigeria are not happy because they feel it is crippling the economic activity of the state. But that is not what the Biafrans think, because to them, they are doing that in solidarity for the leader of IPOB. So I can tell you now that they might be sitting down there in the eastern part of Nigeria, that is a Biafran land, and that is worthwhile because I see that as a support, to the leader of IPOB. Thank you, Miriam.
All right, and for our viewers who are watching us, those are live images from Abuja. There we have our correspondent, Captain Chikwas. And I don't know, before I go to Dr. Matanga, I don't know if you can confirm with us if at all Nnamdi Kanu, the leader of IPOB, has already arrived in court, and if not, what could be the reason for the delay? And if at all he's delayed, or what was the time of the court session?
Yeah, I can say categorically that Nnamdi Kanu has arrived, has appeared before the court. And there is something that happened, yesterday during the ruling, during the decision of the court, prior to the dismissal, the presiding justice, Binta Nyako, did order, one, that Nnamdi Kanu be allowed changing of clothing. Let me tell every one of you that since the 29th day of June 2021, up until now, he has been disallowed to change clothing. He has been disallowed to communicate with his lawyers. He has been disallowed to communication with his doctors. He has been disallowed. In fact, every fundamental human right that is allotted or that is to all intents and purposes due to him has been denied of him. So that same Fendi clothing you see him putting on, he has been on that wear since the very day he was abducted in Kenya up until now. So live pictures that would be shared any moment from now, as he is confirmed to have entered the courtroom. The same Fendi wear he is putting on, he has been putting on, he is putting on at this time.
Very well, thank you so much. Let me just go back to Dr. Matanga. Just mute your device. We'll come back to you in a very short while, Doc. Nnamdi Kanu is already in court there in Abuja.
Yes, thank you very much, Miriam. It is the same thing, the same script, the same way out. This just call. Our role as international agency, a news outlet, a television station, we want to call upon African leaders. We are showing these pictures to show the type of democracy that is in Nigeria. To have pity for the people of Biafra. The killings that are taking place in this state, a country called Nigeria, must be brought to international community. The type of trial that Mr. Nnamdi Kanu is undergoing is illegal, is part and parcel of not the Commonwealth. Nigeria must be sent out of Commonwealth. Nigeria does not conform with the regulations of the United Nations. Nigeria has not conformed with the regulations of the Commonwealth. Her Majesty the Queen cannot allow a subject of a British national with a British passport being molested, being given one shirt, one trouser. Since he was arrested, he has not been allowed medical treatment. He has not been allowed to change a shirt, a trouser. His trouser, his short, his shirt, his underwear, his everything. He has not changed them. What inhuman being government is this? That it does not even allow people to change their own. I don't know whether he eats. You see, no medical treatment. We cannot accept this to go on for a long time. Africa has to wake up and act. The earlier Africa wakes up to act, the better. There is something wrong with Nigeria, which is not in any other African state that I've seen. A population of 220 million people, we are done. Miriam, we are done. This is the tragedy of Africa. And I believe that we have done our best as a television station to maintain the status, to make sure that there is the truth. But let's ask, let me ask you, what else can we do apart from us allowing the platform? We don't fight with guns. We don't have guns to fight. But everybody in Africa has seen the plight of the people. That gentleman who has just come on television told you that it is very good life in Abuja, but very bad life in the eastern part of Nigeria, south. So what is the problem here that we have? We have a problem, and Miriam, I'm sorry. I don't know whether we are still on, but I am shocked. I have no words. Because if the man cannot be allowed to change his shirt, since for how many months that is coming to 1 year, it's very, very embarrassing. Very embarrassing. Very.
And I think also there was another problem there. They did not want his whole legal team to be part of that proceeding, and that was a contention. So I don't know if perhaps Captain Chikas, you can confirm. I don't know if you've had any information from the court. If you can confirm that the whole of his legal team today has been allowed to be part of the proceeding at the Abuja High Court. Can you confirm that?
Can we, Hezekiah Onogure, Hezekiah Onogure, do you want to speak? Do you want to make any contribution? Anybody on the platform who wants to make a contribution?
All right.
All right.
Yes, I think we.
Captain Chikwazi, we would like to. Our show, at least we have brought it to our people. We have done our best.
Yes, maybe Doc, before you close, maybe Captain Chikwas has some last words. Maybe he wants to. Yes.
Captain, can you say something?
Okay, we are still here. You know, the only thing I have to say here is that our viewers should just stay tuned, because we are going to come back, to bringing you more highlights and updates. I'm not alone here. There are also other journalists as usual. Yesterday, I did tell us that there were some people whom we are termed scrutinizers, so to say, that they were scrutinizing people, only those they could control. I mean, journalists they could control to assessing the courtroom. But there are plenty of journalists here, pressmen here, that weren't allowed to enter yesterday, and the same thing applied today. So nothing changed. You can see the huge barricades. Nothing changed from yesterday. Today is the same thing. But I can assure you that I would still be here with my team members. We would still be here until the court session is over. Then we would bring a couple of reports and interview sessions followingly. So thank you very much, Doctor, and the co-anchors there with you. From here, I say good morning for now. Thank you very much.
Thank you very much. Thank you very much, Captain Chikwasa Onukipe. We shall come back to you. We want to come back to cross over to Nairobi, where we want to see briefly. We have 14 minutes. We want to see what is taking place in the Supreme Court. Then we close. We bring the curtain down. Cross us over to Nairobi. Thank you very much, Captain Chikwasi Onu Ikipe.
Its findings to the principals.
Studio Cross
October 2020 in Kisii County, an event that preceded the official launch of the report, which was done at a
Conflicts exist on this continent. One of the most raging conflicts on the continent of Biafra. From 1965 or before that, the Biafrans had their own institutions. Before the colonial master arrived, they have agitated themselves, they have told the world they want fair treatment in a nation called Nigeria. Successive regimes have always tried of the people of Biafra, destroyed them, younger men, many forceful deportation out of your own country. Time has come for the new generation in 2020, 2021, 2022, for people to sit down to find an everlasting solution to the conflict that is around that region. President Buhari promised us that he will finish in 100 days, the first term of office. Boko Haram will be dead. Today is finishing his second term. Boko Haram is even more vibrant than his own shoes. We have landed in very serious murky waters that the people of Nigeria don't know which direction they are going. The people of Nigeria, a big country with a big population, an economic hub of West Africa and Africa, with the biggest reserves of oil, still lingers in poverty. The poverty and rich gaps in Nigeria are wider than the distance between, Mars and Earth.
Mr. Morara will debunk that. On Professor Githu Muigai comments on IBC powers, I think it can be varied. But again, Article 255 protects IBC and all other independent commissions under Chapter 15 whenever there is independence is at risk. So I think that must be taken with caution, because I believe IBC is also one of the commissions under Chapter 15. And whenever its independence is at stake, just the way this court independence was at stake with the creation of the Judiciary Ombudsman, then the hands of the promoter are locked. Senior Counsel Kiragu Kimani cites 138 of the Swiss Constitution. No evidence has adduced whatsoever showing that a president or any other state officer can actually move amendments. And I will refer you, your lordships and ladyship, to paragraph 57 and 58 of volume 21 at page 3027, where we clearly discuss the issue of Article 138 of the Swiss Constitution. It's not a state officer or a president.
And paragraph 58 now
in fact, scholars writing on that issue alludes to the issue of direct democracy and popular initiative. One of the definitions given by the Black's Law Dictionary, it's the people exercising their own residual power in a direct way, not indirect way.
Okay.
The people say that.
And paragraph 58 of volume 21, we say that according to Article 138 of the Swiss Constitution, all popular initiatives are driven by ordinary citizens as a form of direct democracy. And this actually originates at the local and canton levels. I'm sorry to take you back, my ladies and my lords, but under the CKRC report, the people say that our constitution should actually be amended the way it was made. And that, I think, introduces a very high threshold. And I'm sorry to use this word, but under the same report, page 42 of that report, the people had this to say as a recommendation, that one very interesting is the provision of structures of the review process to reflect the bottom-up approach. I know that that's a very sensitive term at this, but those are not my words. They are clearly provided under page 42 of that CKRC report. But then going back to your issue of interpretation, looking at the context and the history, the intention of the people that was in amending what is so fundamental to them, we must start at the bottom, and it comes up. That means now with the involvement of the constitution, county assembly, parliament, and all other relevant entities like the IBC, but should never be seen to be something that is being proposed top. And that's why I was saying that the process of amendments introduced by the Constitutional Amendment Bill 2020 was wrong ab initio, based on that intention and context by the people provided under that CKRC report. For the interest of time, and for the sake of my senior Mr. Morara, I just want to say that the post the 1997 IPG, where the people actually agitated for the People Review Commission, you can deduce that the people were so much concerned with the process and procedure of amendment of the Constitution and the content of the Constitution. Process referring to the popular initiative, parliamentary initiative, and content referring to what I can term as entrenched clauses. So I think that must really be considered. I've referred you, my ladies and my lords, to the Black Law Dictionary of meaning of popular initiative. And I will not dwell further on the writings by Professor Richard Albert or Yaniv Rosnai. I think Mr. Nelson Harvey will do that. And I'll close by saying that my clarion call to the first appellant and those in support is for them to end the hostilities against the Constitution. Though we recognize them as prisoners of war based on the findings of the High Court and the Court of Appeal, and that us on the other side will be willing to make peace with them and preserve and uphold the Constitution of Kenya. For the interest of time, let me yield the floor to Mr. Omoke. But before that, I just want to acknowledge the presence of my Professor Ben Sianya, who actually provided me a platform at the formative years as at the School of Law in Parklands to be his researcher for 3 years in constitutional law. I think it's fair credit for me to recognize him at this forum. So I would like to yield the floor to Mr. Morara. We had a lot to submit, but for the interest of time, I would like to stop there. Thank you.
Honorable Justice of the Supreme Court, I'm very honored to appear before you today. Thank you for the opportunity to hear our arguments. I'll begin with the issue of quorum. When I was filing my petition before, my name is Morara Omoke. I forgot to say that. Morara Omoke, the third appellant, and I was also the petitioner in E416 before the High Court and the 76th respondent before the Court of Appeal. Before I filed my petition at the High Court, I read very carefully the decisions that were surrounding questions on quorum of the IEBC. And in my mind, there was no problem with what I found and what I was seeking the court to find. I was asking the High Court to find that the IEBC lacked the quorum to conduct something very important, which I consider to be a policy issue. When I looked at other decisions like the Isaiah B. Watt case, which has been cited very extensively by the IEBC, I looked at that and I found that, in my opinion at the time, the law applicable was the law that was there before the decision in Katiba Institute, which set the quorum for the IEBC. When you look at the Constitution, there's Article 251, which has been relied upon by the IEBC to identify what they consider to be the quorum of the Commission. And I would like the Supreme Court to distinguish between quorum and composition, because what we have in the Article 251 is the composition, the minimum number of commissioners required to be properly constituted, which is 3. But quorum is a different question. It's about the functionality, the day-to-day operation of a commission and decision-making. You cannot ignore quorum, because if we say that we operate without quorum, then that would be very dangerous. And we know the role that the IEBC plays in our country. It's basically something that goes to the entire republic. I'll move to give an example. If we operated, going by Professor Moiga's argument that when if there's a repeal in the case as he suggested, that we would have no law. Let's take an example. If we had an amendment to the tax code, repealing the current tax rates and providing higher tax rates, and that was challenged at the courts and found to be unconstitutional. Can we actually argue that then we would be in a country where we do not pay taxes until the parliament enacts laws providing for the previous tax rates? That argument would not be good public policy. I move on to the next question on the composition, the second schedule to the Constitutional Amendment Bill of 2020. To me, that was very straightforward. I did mention it in my High Court petition, but I did not consider it to be a very complicated question. And I would ask the court to easily find that under Article 89, already there's a provision for how to delimit boundaries, and the timelines are provided within a duration of 8 to 12 years. That has not been done. So there was no mandate for the Building Bridges Initiative to do that particular responsibility on behalf of the IEBC. I move then to the question of public participation. A lot was said in the High Court and before the Court of Appeal. That may not have been highlighted before you, but in a very short summary, what was found is that the promoters, who we argued then was the president, did not comply with the procedures set out in the Constitution in terms of public participation. It's very straightforward. What happened is that initially they went around the country, views were collected, that's all okay. Of course, we saw some problems with that, how it was done, because basically what was happening is that those collecting views moved from town to town in the Republic, collecting views in 3-star and 5-star hotels. Obviously, who is going to be in those kind of fora? That kind of fora, it's the elites, the poor, or the ordinary, what I would call, I wouldn't use the word poor, but what I would say as the everyday Kenyan may not have that access to give their views. So that was one of the areas where they failed. But more importantly, when the bill was published for the purposes of now collecting signatures, that was on 25th of November 2020. And the signatures were collected from the next day, under 12 hours. So there was not opportunity to educate the public on what was contained in the bill. Another problem which was highlighted and accepted at both levels of the High Court and the Court of Appeal, which has not been challenged, was that there was no consideration of the because it was done, the publication was done online, there was no effort to consider the internet connectivity in our country, which when I look at the Kenya Population and Housing Census report of 2019, volume 4, was found to be 22.6%, and the access to computer was 10.4%. So if you do it online, automatically you lock a vast majority of the people from being able to see the bill before they collect the signatures. And if you do it the next day, it means you do not care for whether they were given the opportunity. And if you look at the decision of this court, the British American tobacco case, you gave us the guidelines that we must look at when we weigh an action that has been undertaken to see whether it meets the threshold for public participation. And when you look at that case, many things were not done. For instance, there was what is happening in that case is what we would say is illusory, what is cosmetic, what does not give the public reasonable opportunity to study the bill before they can give their consent, before they endorse. So what that means is that for the 4.4 million signatures that were collected, they were of no value because a vast majority of those people were just signing before studying the document. When you look at the amendment bill, it contains about 74 clauses. Even for us who are the experts in the law, we may need some time to study those kind of provisions before we give our views. And that's why when you could see even from the filing of the petitions before the courts, people took time to study those provisions. So you could not conclude that doing it under 12 hours of publication is enough. There's a lot I could highlight there, but I think that's enough just to show what exactly happened. When it moved to the IEBC has argued that they do not have any responsibility to ensure compliance with public participation. That is wrong. When you read Article 10, it imposes on all state officers and even the commission, being one of these institutions required to comply with Article 10. Those are values that must always be reflected in their decision making. So when the signatures were brought before them, the first thing they should have done is to consider whether there had been public participation. They had that responsibility. They had to consider if on their part they have actually there was civic education before they process that, and that's a responsibility that solidly lies within the jurisdiction of the IEBC under Article 88. So on that question, the court should easily find that there was no public participation, should not entertain any argument to the contrary. I will move then to the issue that is before us in my appeal. The appeal which seeks to an interpretation of Article 257.10 to establish whether indeed in our country we should be having more separate and distinct referendum questions. I'll begin by laying a foundation based on the judgment of the Court of Appeal. When the judgment was delivered on 20th of August, I listened very keenly to the analysis of each of the judges, and indeed when the judgment was availed to the parties, the hard copies and the soft copies, I read, and my conclusion was that there was an error in the tallying of the final vote of which judge voted to uphold or overturn that finding. So when I looked at each analysis, my view is that, as I agree with Justice Ouko, that it appears that there were 4 votes to uphold the finding of the High Court. So to be diligent, I did send correspondence to the Court of Appeal. I wrote a letter dated August 25th, 2021, which I dispatched to the court on the same day via email. And I received a response. Rather, I sent it on 24th of August, dated 24th of August. I received a reply on 25th of August. The letter was addressed to the President of the Court of Appeal, and I was very respectfully asking him to look at the tally. And I gave grounds, and I pointed out what I thought was what was contained in the judgment, and why I think the vote should be 4-3 in favor of upholding that finding of the High Court. In his reply, he said, which was conveyed to me by email by Registrar Lorraine Ogombe, was that the view of the President was that there was no error. The reason I did that is I did not want to saddle the Supreme Court with an unnecessary appeal if indeed that was an error. So having satisfied myself that I've taken the right steps, I approached the Supreme Court through the appeal that is before you, appeal number 11 of 2021. So I did that part, and I think the court can look at the analysis and easily reach a conclusion that that finding of the High Court should be upheld. But I'll not rest there, because it's important for the Supreme Court also to hear what is the justification for seeking that kind of a finding. I'll ask the court to read the text again. I know we've read many times Article 255 to 257, but I'm asking again. All of us, even my opponents, maybe they might be convinced when they respond to me, especially the IBC, which is there to respond. I would like to read. I did draw a table, which is in my submissions at page 8. My submissions are dated 24th of November 2021. In that table, I tried to do a textual analysis of the words in Article 255 to 257. I looked at words that I used there carefully. I saw a word called a proposed amendment, the amendment, an amendment, a bill to amend this constitution, the bill, any bill, a general suggestion, a formulated draft bill, a draft bill, the draft bill, a bill, and there was a word again repeated at the very end, the bill, which I've just drawn them just to try and analyze, because we seem to be all in agreement, the parties before you, that it's important to look at the textual analysis. So when I do the textual analysis, my conclusion was that the way the words have been used by the Constitution in those clauses can only mean that they are used in a singular form. Also suggesting, therefore, that when we prepare a draft bill to amend the Constitution, it ought to contain a single amendment. But if there is a need to contain anything more than one, it has to be something that is consequential, that arises from that amendment being made. Because it happens, you could amend one section and it touches on another one. But the primary amendment should be one. So that's why I want us to start on our analysis when hopefully I am praying to the court, when you do the analysis, to begin at that point, which will then assist us to reach a conclusion that a draft bill should contain one issue or one amendment. However, if the court also looks at that, it should not rest at that point. Also look at the findings and see that if an amendment is just one amendment, then when we go to the referendum, the voting should be on the amendment, that single amendment, in a way that allows the people to select just one item at a time. There's a possibility when you do an amendment, you may have then what I'm calling the referendum questions, whereby just a single amendment elicits the need to get responses from the people on more than one issue. I'll give an example. If there was an amendment to alter the presidential term, that kind of an amendment will require some responses from the people. Do we agree that we should alter the presidential term limit? That will not end there. We may need also to hear from them. Do you want to increase it? Do you want to increase the term, presidential term, or reduce it? Then there will be another question. How should that amendment be? Do we have a 5-year presidential term or 4 years? A 5-year term, that is, and then is someone entitled to getting one term only? So you can see that just one amendment can lead to more than one referendum question. So what I'm asking the court, by looking at my prayers, the main prayers in my petition, if the court can reach a conclusion that we should have a draft bill with one single amendment, it will be able to resolve the problem. If we have an amendment that is framed in terms of the distinct referendum questions, that will be able to deal with the problem. This issue that is before you is not theoretical, it's not speculative, it is based on a real issue. Before you, what has triggered the litigation, at least for all the petitions before the High Court except one was the fact that there was an amendment bill, what we're calling the Constitution of Kenya Amendment Bill 2020, which, as we've said, contains 74 amendment clauses, but there could be many more amendments. If you analyze each and every clause, it could generate more than 74 amendments. So therefore, when I approached the court at that time, I'm informed by Article 22 of the Constitution that if I can, as a citizen who is doing his duty under Article 1 and Article 3, Article 1 and 3, to defend the Constitution, I have to approach the court and say, I am feeling that there is a threat on the Constitution, because if we conduct this referendum, we end up with a yes or no question on 74 amendments. It's dangerous. It's not good for the country. It will decimate the Constitution. And I'll give examples. When I looked at the amendment bill, as a citizen who is taking a vote, I'm just going to pick a number of examples. I saw a provision allowing a tax break. I would be very happy. And I think any entrepreneur out there would be happy to get a tax break. But as an advocate, I found another provision telling me that if we pass the amendment bill, then I cannot conduct election petitions until when beyond the Court of Appeal. That litigation ends there. And I found that is a limitation on the rights of those who litigate, because the provision is there. Matters of political rights should not be limited. As a litigant, they should be able to get the opportunity to litigate to the end. As an advocate of the High Court representing them, that's my trade. I should not be limited to end my litigation in the Court of Appeal. When will I appear before you, Honorable Justices of the Supreme Court, if we end all the litigation in election cases at the High Court, at the Court of Appeal? So I'm concerned I cannot accept to vote for that kind of an amendment. But I am seeing the tax. So I'm being put in a dilemma as a citizen when I'm taking a vote on that kind of a bill. I look at other dangerous provisions that would have totally destroyed our judiciary, like the Judiciary Ombudsman, which was dangerous for our country, not just for the judiciary. So basically then I would like to highlight other provisions of the Constitution which should aid the court to reach a conclusion that we should always have separate, distinct referendum questions, and we should have a draft bill only raising, or rather containing only one single amendment. We begin with Article 32, which gives the people freedom of opinion. You are entitled to form your opinion, but if I'm given 74 amendments all in one document, what opinion will I form? If I have to still express my decision at the end, having been given more than 74 contradictory, confusing provisions, some of which I agree with, others which I do not approve of. I go to Article 33, freedom of expression. If you give me all of them in one document and you tell me to express my freedom of expression, I will not be able to exercise that freedom. If you give me this in a vote, Article 38, my political rights, when I'm seeking to vote as a citizen, and I'm just given all the options tied in on one ballot, it cannot be in line with Article 38, where I'm told that in Article 38, my freedom, the right to vote includes being able to vote in a way that, to be able to express my will in an election freely. It cannot be free if it is like that. Then I go to the general principles for the electoral system of Kenya at Article 81. They have been laid out. What are the principles that the electoral system should be able to enable? Simple voting, efficient voting, voting that is seen as transparent and accountable. It cannot be transparent and accountable if you get 74 amendments and you are voting in one. It's like, I'll use a simple analogy. If we were to be given the 6 ballots that we usually do in our general election, and you're told you have all your presidential candidates, they are in one ballot, or rather they are classified, and you're told you have this presidential candidate and you have this member of parliament, all the way from top down the ticket, vote only once. How is that going to be, how does that sit with the Article 38 and Article 81? So basically what I'm telling you, the justices of the Supreme Court, is that the issue of the format of referendum questions and the draft bills, it strikes the heart of the Bill of Rights. And when you interpret the Constitution and Article 259, then you have to look at that. You have to look at whether the kind of thing that is before you will it enhance human rights, will it enhance fundamental freedoms of the people. As I come to closing this presentation, I would like to urge you, the justices of the Supreme Court, that what we are doing here is something, basically a point of inflection for our country. And as President Joe Biden usually says, it's on us. It's on you, the justices. It's on us, the advocates and the people, to comply with the clarion call in Article 3 of the Constitution, that we have to ensure that the Constitution is respected, upheld, and defended. I thank you, judges, and in case there's any question you would like to ask me at this point, I would be happy to take it, or I'll take it at a later date.
Thank you for your submissions. I think we'll reserve the clarifications later.
Thank you, Honorable CJ.
Yes. It is now 1:20. We will take a lunch break and resume at 2:30 to hear from the respondents. 2:30.
As we break for lunch, my name is Ochiel Dudley. My lady, I just wish to clarify a really small and harmless report I've seen in one of our dailies concerning yesterday's proceedings. I have seen it reported that 2 advocates sought leave and were granted permission to withdraw from the proceedings, and that Ochiel Dudley was one of those 2 advocates. I just wish to clarify, my lady, that Ochiel Dudley did not seek permission to withdraw and did not withdraw. He remained seated yesterday and has attended today as he will tomorrow. Most obliged, my lady.
Thank you. That is well noted.
Thank you, my lady.
2:30.
Peace must be our goal and our guide. And all that we strive for as a human family, dignity and hope, progress and prosperity, depends on peace. But peace depends on us.